So as we begin our today's conversation, we are asking ourselves the simplest question. What's a Bill of Rights? Why do we need a Bill of Rights? The ones that have been provided for in the Constitution, how much of those gains have we made? Is there room for improvement? And if there is room for improvement, how do we go about it? Now, the most essential part of any Bill of Rights is the simplest thing. How do you apply this Bill of Rights? Now, when you ask yourself how you apply this Bill of Rights, is rights don't exist in air. You must be able to enjoy them for them to be able to be a lived experience. So starting with Mr. Kipchumba, what was there before the current Constitution, and what does the current Constitution provide on the application for Bill of Rights?
Thank you for that question, Mr. Nkarichia. First of all, the pre-2010 era marked a really gloom state for me, where rights were applied vertically as among an individual and the state. Let me draw for you an illustration. This is a poll. This is the citizen, and this is the state. Rights only applied as among the citizen and the state. And also to note is that rights were mostly civil and political rights at that time. There were no provision for economic, social, and cultural rights. I will get back to that later on when I talk about Article 25. This vertical application of the Bill of Rights was mainly centered on the idea that the state wielded so much power, hence the individual had to be protected. And just to answer the question simply, as Nkarichia has said, rights were applied vertically, not horizontally. The horizontal application of the Bill of Rights came later onwards after the promulgation of the Constitution of Kenya on 27th August 2010, whereby the citizens wanted for individual actors to be held accountable for their misgraces. Because actors such as clubs, private entities themselves, and multilateral company wielded so much power. A case in point, I'll maybe refer to the Rose Wangui Mambo versus the Limuru County Club case, whereby the appellant, who's Rose Wangui, was a member of a club. That club enacted bylaws that prevented Rose Wangui to perform on the matters voting of the club. These, the court said, amounted to discrimination, which is a constitutional right, and hence this can be seen as an example of how rights now applied horizontally, as between a private entity, which is a club, and an individual who's Rose Wangui. I think that answers the question.
Thanks, Mr. Kipchumba. Now, to go to Professor Mbani. Prof, when someone says a right, a fundamental freedom, what is a right? What is a fundamental freedom? And why do we have Article 19.2 expressly stating why we need rights and fundamental freedoms in the Constitution?
Thank you, discussant. What is a right? I actually don't know the answer. I'm sorry to disappoint, because I did my master's and PhD in human rights and did not get an answer. What I got instead was classes and classes of different philosophies trying to explain what rights are. In the end, I wasn't given any. I can, however, share what I think human rights are, going by the way our Constitution is framed. The Constitution takes one approach, which I think is a natural law approach, when it's defining rights in Article 19. And I think it takes an approach that says that rights are inherent in human beings. That which you have as a human being when you are born, that is a human right. There are things you have just because you're a human being. For example, you have to live, you have to have dignity, isn't it? You have to have worth as a person. You have to be protected. Since our bodies, for example, are vulnerable to injuries, isn't it? What do we call ourselves? As endoskeletons, our flesh is out, not the bones. So we are very vulnerable. We need security all the time. So the Constitution takes the approach that once we are born, then we must find that we have rights immediately as human beings. That approach, therefore, cannot even begin to list all the rights exhaustively. So you'll notice again that when you read Article 19, you'll start seeing that they're saying, yes, the Constitution gives you rights in the Bill of Rights, but it says this is not everything. There's room to discover more rights. As human beings, there's more than the Constitution says. And I think that is what I would talk about human rights for now. But the other thing I would say is, that at the core of human rights is the concept of dignity. And if I was reduced to say rights in one word, I would just say dignity. Once you can realize dignity, you will realize human rights. That would be my answer to your first question. Do you want me to say more? Okay. Yeah. However, if I was to go to how we have lived here, I can just say a summary that we've had big problems with realizing even these things that we think are obvious as human beings. We've had difficulties enjoying rights historically, from the colonial times where we were not even thought to be human beings, or if we were human beings, not at the same level as white people or Asians or Arabs. So we are always discriminated upon from the beginning. And once that happens, your dignity is out. So we have lived that phase where our dignity was disregarded all through the colonial phase. A lot of the rights you see we talked about, the freedoms, and I think that can answer the second part of the question. A lot of the times we wanted to be free. Why? Because we were colonized, because we were in bondage. So you'll notice that a lot of the rights we agitated for a bit more noisily were, I want to be able to speak, I want to be able to express myself, I want to be able to move from one place to the other. Remember, we had a Kipande system. I want to be able to take part in governance of my society. Those would be the initial rights you'll see a lot of noise about. Yet, in reality, other rights were also disregarded, even the colonial phase, which is part of what we are claiming in the new phase. So, for example, socioeconomic rights, our welfare as a people, food, the right to food. If somebody took away your land, what do they mean? Do they mean you'll go hungry? The right to shelter, the right to health, to be able to enjoy the best attainable state of health, to receive medication when you are sick. Those rights have also suffered in the past, yet you'll notice the colonial phase, we don't talk much about them. In the first phase before the Constitution doesn't even recognize that. It's almost exercised through other avenues, not the Bill of Rights. And then in 2010, you begin to see us enjoying much more deeper rights than just the freedoms of expression, of assembly, what we call civil and political rights. Now you are seeing much deeper rights, what now we are calling socioeconomic rights, and we go on to other generations of rights. You see environment, you see even rights around gender, and those kind of expressions. So we are moving forward, in other words, to enjoy the full compass of human rights. In summary, that's what I would say. Thank you.
Thanks, Prof. Ahmad. Now, if you have understood what's a right and where the Constitution provides it, Ms. Komba, how have courts interpreted and applied these rights when you look pre-2010 and the post-2010?
Thank you, Mr. Nkarichia. So if we look at pre-2010, just as my colleague Brian has said before, rights were only for a specific class of people, and there was only a vertical application of the rights, meaning that it was only from the state to the people. There was no horizontal application, and what the the 2010 Constitution or the Bill of Rights has came up with, and the changes are now that this right can now apply for both. And in fact, the state does not grant us the rights. If you have followed what Prof said, human rights are inherent, which means that we are born with those rights. And all they can do is that to protect them, maybe promote the right and make sure that we are enjoying those privileges. By the way, I also wanted to remind Prof that in March, when we talked about what is a right, when we were talking about the book project, I don't know if you can still remember, I also asked him what was a right. Like, yes, you're talking about human right, but I'm pretty sure the first question will be, no, what is a right? And back then, he told me that a right can't be defined specifically because it is a chameleon-like term, so it depends on the strict sense in which you are defining them. So it can be defined like, for example, a privilege. A right is a privilege. He also told me that it can also be defined as the power to create legal relationship. But yeah, I think he lied because now he has just said that he does not know the meaning of rights. Yeah, so far, in how it has been applied, we can look at it in many cases. So far, maybe we can use the Mitubel case. It's quite a popular case, and I'm pretty sure that most of you have read it. And since we are talking about human dignity, right to housing, and all those things, you have seen how they have been able to, they were able to fight for their rights for adequate housing, and they were granted their rights and houses because that is a fundamental right that the state on them. But also in so many other cases where you have found unconstitutional, which were also declared unconstitutional because the state was violating the citizens' rights. Yeah, I think that responds on the application, or did I miss a part of the question? What was the question?
Now, if you're saying it's for the citizens to try and see, and the courts try and uphold the right of the citizen against the state, the simplest thing that comes to mind is who can sue or who cannot sue the government. Who can sue or who cannot sue to protect a right. Now, Mr. Kadima, how was the concept of who can sue and who cannot be sued changed under the pre-2010 Constitution and the post-2010 Constitutional matrix?
Thank you, Bwana Nkarichia. In response to that, I think the fundamental part of it is to know what a right is, but the previous two speakers clearly don't know what it is, so I don't know what I'll be talking about. Enforcement. But that being said, there's been quite a lot of change on enforcement of rights, which is now captured under Article 22 of the Constitution of Kenya 2010. And that provision has had quite a lot of history for it to be framed the way it is. I'll just start by the recent provisions as we go backwards, then we'll note the change. For example, if you have your constitution and you open Article 22, you'll realize any person can approach court for violation of rights in case they have been infringed, threatened, or there is possibility of them being infringed by the government or by any other person. You'll also realize that another person or a person can represent another person before courts of law. That's when now we say suing. But it necessarily doesn't need to be in courts of law. It can be in different enforcement bodies, such as the independent commissions. You'll also realize that Article 22 has very important elements which are closer to mwananchi. For instance, it says two very important things. One, there may be no fees when you file a reference, maybe for violation of rights. And number two, it also says you can actually institute a reference for violation of human rights through informal means. It doesn't need to be formal, which are two central things to mwananchi. You realize that most Kenyans might not be able to afford high fees of filing a constitutional reference or have the education to file formal documents before different bodies. And these provisions have a history. When you now go back in time, for example, if you look at the 1963 Order in Council, I think it should be, was it 198? I can't really remember the specific number, but it's the one that now introduced the 1963 Constitution, which was signed back then by Her Majesty the Queen Elizabeth. You'd realize that it had a section, should be section 27, which had something that mirrors what we have in Article 22. It was very formalistic. The body which you could go was the Supreme Court at that time. So you realize, for example, only a few people could access the Supreme Court. Somebody in Lodwar was unable, maybe, for example, to travel all the way to Nairobi where the Supreme Court was located. It was also formalistic in terms of the documents that were supposed to be filed. So it realized that it limited the access to bodies. A normal or a usual mwananchi, like myself, could not file for a constitutional reference to enforce the Bill of Rights in case they have been violated or infringed by any person. So the 2010 Constitution came to remedy that. And we appreciate the fact that in 2013, Chief Justice Emeritus Willy Mutunga actually initiated the Constitution of Kenya Fundamental Rights and Freedom Enforcement Rules, which we now call them the 2013 Mutunga Rules, which have very important provisions. For instance, you can file a reference through a letter. You can just write a letter, and your matter should be addressed, which is one of the things that is informal about the 2010 Constitution. So any person in this republic can actually write a letter. But I have a challenge with that. Last year, I tried to write a letter to the judiciary seeking violation of rights because I'm unable to read the Constitution in English. I wanted to read the Constitution in Swahili, which is also a national language under the Constitution. And there's no formal document written in Swahili, which is a constitution of the Republic of Kenya. So I wrote a letter, but I was advised that since I'm an advocate of the High Court of Kenya, I cannot write a letter to as a constitutional reference for violation of rights. I was told since I'm an advocate, I need to proceed through formal documentations. Well, of course, that's a mistreatment, because why do they expect me to know or to write the formal way and there's an informal way which should be much easier? I thought accessing justice should be much easier. So I appreciate that over time we have these informal means in the Constitution, but we now need to see how we can implement it to be even less formal. Further, I also tried to approach court and tell them that this is a reference through that same letter. And I wanted it to be filed for free, which I was told that when you go to file a constitutional reference, each order, for example, an order of mandamus, has a specific price to it under the e-filing system. And it came to about 48,000, the total orders. So I said this is too expensive. So I think it's one of the things that we need to remove from our normal administration of justice for any person to be able to sue. Of course, you can be a representative of any other person. And maybe later in this discussion, I'll have a discussion with Mr. Nkarichia. I think he appeared in the Supreme Court in one of the cases, Law Society of Kenya versus Communications Authority of Kenya, whereby the Law Society of Kenya tried to pick up an appeal on behalf of the people and take it to the Supreme Court for violation of human rights. But their standing before that court was actually denied simply because they were not the original party to the case. So we'll have more of that discussion, but I think that's an introduction just to show that those a formalistic view from the 1963 Constitution, and the 2010 Constitution came in some way to ease the access to justice for enforcement of human rights. Thank you.
Thank you, Mr. Kadima. Now turning to Prof. Ambani. Mr. Kadima sets out these challenges that appear to arise when you try to enjoy the Bill of Rights. To what extent do you think the legislature has tried to advance the Bill of Rights, and do you think it has been successful?
You have a way of getting me to comment politically. If I look overally at the Bill of Rights, I think that we can't say at once that the legislature has fully succeeded. We can't also say that it has failed fully. I think we can say that there have been some gains. There have also been some lost opportunities, and that we could do better. So perhaps maybe I should start by linking with Mr. Kadima here. One of the problems of the Bill of Rights was actually just implementation and enforcement. Okay. There's something that the Chief Justice was supposed to do, which is to make rules, to make realizable the Bill of Rights. Kadima is just mentioning that there's still a problem with that. I don't know whether Parliament has discussed this matter. You can check the answer. I'm not sure it has. Why what Kadima is saying is important is this. You can't enforce rights if you don't have capacity to enforce that. And many times ordinary people don't have capacity, so you need someone to represent others. The biggest case I can remember is the Wangari Maathai case. I think those who are 35 and older can remember. The government wanted to put up something in Uhuru Park, I think the Times Towers. And Wangari Maathai, university students, human rights activists went and opposed it in court. The court said that she had no business bringing a matter that doesn't relate to her. You know, and she's not the environment. She can't complain about the environment. So we began talking about enforcement. Okay. And so when you see the wording of the new constitution critically, you will see that word is very clear that anybody can come to court, but you will also see that they are actually saying you can bring it on your behalf, on somebody else's behalf. And you also see that the provisions we're dealing with actually also talk about technicalities of procedure should be taken away. I think you've seen that. And that the Chief Justice should now make rules. And that even without those rules, the Bill of Rights still stands. There's also a history to that, if I was also to indicate a story before I answer you specifically. When the Chief Justice is, when we ask the Chief Justice to write rules, it's because we remember that the old constitution had the same provision requiring the Chief Justice to make rules. The Chief Justices never made any rules, yet they continue to deny ordinary people their rights because Chief Justice had not made rules. In one of the most, since you're not technical here, but I can just mention, one of the most ridiculous cases was where the Chief Justice himself was seated. I think it was Miller. And he actually said that the Chief Justice has not made rules, and it was himself. so you can't enjoy your rights, you know. So we've been very clear about enforcement. So if I was to start there as you want me to, and then go to how has Parliament resolved this? I can't remember any discussion of Parliament about access to justice in this particular aspect. The other solution we proposed in the new constitution, which you'll see in the enforcement, is that we proposed, in addition to courts, something more humane. You understand? Something, a body that is more close to people, that is not technical, that you would even approach by a letter. And that is the Kenya National Commission on Human Rights. That is in the constitution. I think its own provision is actually in 59, Article 59, but you can see that it's anticipated as part of the enforcement mechanism for the Bill of Rights. Parliament was supposed to write legislation to ensure that this, that this enforcement is then reinforced. What did Parliament do? It took the option that the Constitution gave them, that they can actually write 3 laws, debatable. I don't know whether it's good or bad. We can discuss that in another forum. It wrote actually three commissions instead of one. One on gender, the other one on human rights, and the other one as an ombudsman for administrative justice. After doing that, Parliament itself, so I'm talking about the role of Parliament now, continues to deny these bodies income, money. All budgetary provisions of Parliament have been to stifle these commissions. Every time I speak to these commissions, their biggest concern is, number one, resourcing. The second is actually their independence. Although the Constitution guarantees the independence, and Parliament is involved in securing that independence through the appointment process of the commissioners, since the 2010 Constitution, the government has been stifling the independence of the commissioners, the appointment process, and Parliament has done nothing about that. You can check. The farthest they can go, perhaps just one shout or the other. Yet every time you find commissions having commissioners that are very, very close to the executive, some of them, not all, some of them without proper human rights record, and sometimes these bodies have gone without any commissioners being appointed. In fact, if you check the history of the Kenya Human Rights Commission, the last 10 years, they could have gone for a significant amount of years without commissioners than when they've had commissioners. Parliament has not been doing much in that. So you can see that it's falling short in nearly every area, oversight, budgeting, and even legislation. And I think for me, the answer is what I said. They have done something. So for example, in this, they've actually made laws. But again, following up and oversighting to ensure those institutions that have created stand, I think there has been a problem there. If I look keenly on other rights, so for example, socioeconomic rights, I don't get the feeling that Parliament has done enough to, for example, protect the housing rights of the ordinary people. And you can do this experiment. If you wanted a proper place to go when you're looking at what standards do we apply for housing in Kenya or evictions, I think the High Court has done much more than Parliament, and even just setting the standards for evictions in the Republic. And I have problems, therefore, if you find that the court is setting more rules than the legislature, then the legislature, for me, appears to have failed in that realm. We can discuss this more and more. If we went to the other issue that is being discussed in the other room, I'm really troubled even more. You would have expected Parliament to be at the forefront enacting legislations about, say, demonstration and picketing. I am disturbed because even the first draft I've seen, trying to regulate the area of peaceful demonstrations, have been more to curtail rights than to expand them. There's a draft, 1 or 2 I've seen already. One of them I would call the Kindiki draft, when he was Minister for Internal Security, where they are saying the burden falls on the person organizing demonstrations. And you have to make sure the security is maintained, you have to tell the police, you have to... It's crazy. The requirements are such that you can't even have a demonstration. If there's any damage, you're the one to pay. It just takes away the whole rights that the Constitution is doing. That is the only bill so far in Parliament. That's the only initiative so far in Parliament in an area where we have lost lives. We've lost several young people. In fact, the data is contested, as you know. We're even just beginning to talk about reparations for those families that were affected. And yet, Parliament has been mum, even to talk about the Gen Z revolution and on the right side. When they speak, you notice that they are conflicted between their political interests and protecting the ordinary rights of Mwananchi. And I think they haven't been useful on the Gen Z, which is why I think the people themselves have just taken this up and have been pursuing it. So I think we can talk for the whole day, but if I just pick the main areas randomly, Parliament has done back, sideways, something like that, and I can't give them a vote of confidence, but I can't also say they did nothing completely. There were things, but I think the things were somewhat not followed up to the end. Thank you very much. Yeah.
Thanks, Prof. Now, turning to Brian, you promised us to have a conversation on social and economic rights. It has been a question and an issue for some time, but the government does not have enough resources. Professor Mbani has just said constitutional commissions suffer from inadequate resources. So if you look at Article 24 and 25, just break, what's a social and economic right, what differentiates it from other rights? What is this progressive realization, and how have courts treated this concept of progressive realization? Thanks.
Thank you, Mr. Nkarichia. Let me start by first differentiating between socioeconomic rights and other rights. In simple terms, we have the political rights. I am very sure every one of you knows the right to vote, the right to assembly, and the right to picket, maandamano. And then we have these other rights that we essentially can't live without. We have the right to food, the right to housing. Those are what we call socio-economic rights. And yeah, the transformative nature of the 2010 Constitution is in such a way that the rights, socio-economic rights, are to be granted by the state. The state has an obligation to ensure that we enjoy these socio-economic rights. However, there are some certain circumstances where the state might say, we do not have the funds to implement these. And that's where the aspect of progressive realization comes in. Progressive realization, okay, I'll put it in very simpler terms. You want to purchase a car. You don't have the money, but there is an option for you to accrue the money slowly and then come and buy the car. Now that is where I link it with progressive realization. The government cannot do that at that time, but it can do it at another time. But this also does not mean that the government should not fulfill its socio-economic rights. As Prof said, anyone, once you realize dignity, you've realized human rights. A case that very well mentions this is County Government of Bungoma versus JOO. It's a matter whereby the rights of a woman to maternal health care were infringed. However, Ngugi in that application, and this is where also application links with the international human rights framework, we have something known as the minimum core obligation. As much as the government says, I do not have these resources, but can they ensure the minimum core? Such as, in the case of County Government of Bungoma, the minimum core obligation was dignity. Can you ensure dignity while performing the acts that pertain maternal health care? Can you ensure privacy while also performing matters health care? This also links with general comment number 3 on the, general comment number 3 of the UN. I think that answers the question.
Thanks, Brian. And to Ms. Kenaya, as we wind up, Brian has brought along the concept of international law and how it relates with the Kenya's legal framework and our constitution. Just a question for you to try and tease this out. Do you think we have taken enough steps for the government to comply with its obligations internationally to respect and uphold human rights? That question comes when you listened to the last speaker before we broke for break time. He was saying there are proceedings in the United States that seek to see Kenya's compliance with United States regulation as a major non-NATO ally. So you hear kidnappings, you hear abductions. They seem not to comply with what the international community will expect of the government to be doing. So for you, Ms. Kina, Do you think the government has complied with its international obligation, or do you think there is still room, and why?
Have you asked me that question because I'm not Kenyan? First of all, what I would want to mention is that the Kenyan Bill of Rights is one of the most progressive that I never seen, like even compares to ours. And also, even if when you look at it, you really see how it's very comparable to the African Charter on Human Rights and People's Rights. But then, yes, if we look at pre-2010, these same issues were there. And in fact, the issues of these issues of repression and these other things were one of the reasons that even made us look for this new constitution and worked on the 2010 constitution. But as long as they're trying, as long as the government, the state is trying to do all that they can to make this right accessible, while providing horizontal application, these other bylaws to help people, or even accessing our economic and social rights, I believe that there are still rooms to do better. And in fact, that is even why I like what Article 19.3b say. Yeah, I'm sure it's 3b. So 19.3b talks about, says that, well, we recognize all these rights, all the human rights, in all these rights in the Bill of Rights, but still we know that the list is not exhaustive, and it is giving us room for more, and that is giving us a room to for more human rights that can be further human rights that can come up in the future. So, yeah, as the society is changing, as we are progressing, what kind of other right that we can also be working on? What other right that we can make sure that it also fulfill? And talking about that, we can even look at what ECOWAS did recently with the right to internet. Yeah, so I don't think that is a right that is in the Constitution. They didn't mention that we have we should have internet, but look at internet is a way of accessing information, which is also a constitutional right. And by recognizing the right to internet as an international, as a fundamental human right, it shows us that there are still more doors to work on these other things that we seem not to do. On the other political part of the question that he asked, I will let Prof respond so that I'm sure I go back to DRC.
She might be deported back to Congo. Yeah, I think the way I understood you to be asking is that how are we faring with our international obligations? And Kenya has signed to many, many treaties in the world, many, many. The major ones are, but I think I'll keep it informal, but the major ones would be like CEDAW, the one on women's rights. There's this treaty on International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights. That is the world level. There are also treaties on the child, on the Convention on the Rights of the Child. There's a treaty on the migrant workers. There's a lot of regimes on refugees and all that. And then at the African regional level, which is where I like to operate myself, we have the African Charter, we have the African Children's Charter, we have the African Women Protocol. I'm just mentioning the names quickly in an easy way, but the treaties are usually first named in very, long names and complicated codes, referencing them and all that, but I won't go to that. But the whole idea is that there are treaties that set international normative standards that are then required to be implemented by states that sign onto them. And Kenya has signed nearly all these instruments I've mentioned, actually all of the ones I've mentioned. And it's expected to come home and implement. And I don't know whether we want to go into that area, that debate on domestication of international norms. I can just mention in passing that there's a challenge there. Because once you sign a treaty, say in Geneva or wherever it is you've signed it, or Banjul or wherever, you're supposed to come back home and implement. But there are usually difficulties of directly applying international norms in a municipal system. Some manner of modifications are required. Our constitution now. Our constitution now requires that once we sign a treaty, it just applies, but that has had difficulties here, and I don't think it's good to go there unless you want us to keep strictly go. There have been a lot of questions, even in courts, about whether they can apply directly. I think that's a discussion we can have another day. But I want to mention that Kenya also reports to international bodies established by these treaties on the progress they are making to realize human rights. And a lot of times issues have arisen in a number of areas. Pick any area, I can tell you things that have been said about Kenya and the problems they have had. We've had problems of refugees, you know that you're a foreigner, but you're not a refugee at least. International law has been asking us to ensure that refugees can live peacefully and work peacefully among the people, not being restricted in the camps. You've seen recently that the government has implemented that. There are problems politically, of course. There are problems integrating, but that's one of the things government has done. But international law also requires that everyone should have the freedom to participate, to demonstrate, to assemble. We have seen Kenya clearly in breach. You've seen a number of statements by international human rights groups on Kenya's treatment of its civilians exercising this kind of rights. We are already at a place where I'm sure difficult questions are going to arise in a very short while. And there are other controversial issues. I don't know whether this is the forum to talk them because they're just too complex and controversial for no good reason. Kenya has been asked severally in the near past about the treatment of LGBTQ. You've seen that in a number of treaty bodies asking us what we are doing. But recently you've seen that the Supreme Court has been able to speak very strongly for those rights. And I'm sure Kenya has something to say. So we have different rights, and I think we have implemented some well, some we are really struggling. But I think the bottom line is, if you were to ask me, in terms of legislations, we've done a good job. And I join Kanai in saying that if you look at the Constitution alone, it almost fulfills as much as possible the international normative framework. If you're looking at something like the Convention on the Rights of the Child, it almost fulfills as much as possible the international normative framework, which is the Convention on the Rights of the Child and the African Charter on the Rights of the Child. But whenever we report, questions still arise. For example, female circumcision. Those questions have been asked in a number of reports. We have in a number of periodic reviews that Kenya has gone through. Boy child circumcision. It's also an issue that Kenya still has to grapple with. Culture, what we call backward. I don't like the word backward because sometimes it's also used to colonize us further. But some of our cultural practices have been questioned, even in these forums, and we've been asked to say before the international bodies what we are doing to make sure that what they call backward cultural practices do not affect, say, our girls. We also make reports on socioeconomic rights, for example, on the International Covenant on Economic and Social Social Rights Treaty. And again, there are issues of housing have come in. We still have informal settlements. Kibra is always the one that stands out, but there are many in Nairobi alone, several in Nakuru here. We have informal settlements, and many Kenyans actually are not living in a good house at all. And there are reports to that effect, and Kenya has been asked several times to implement that. Brian talked about progressive realization, and Kenya keep saying, okay, we are realizing that progressively, but I think there's a time when you really have to move with speed. The government has been implementing, for example, the National Housing Program. I don't know whether that will be able to satisfy the international treaty bodies when we are reviewed next, to say that Kenya is now doing well. Kenya is also implementing the health program under SHA, social health program. There are many complaints, initially by doctors, mission hospitals and all that, about the practicality. I don't know what will come out in the next review, whether this will be seen as a good move that Kenya should take forward or something that is taking us negative. But yes, we have international frameworks, we have the standards, and we also report to those treaty bodies. And I think there are things we have done like the ones I've mentioned, and I think each one of them actually has challenges that can be raised. And I think the jury is still out there about the recent measures. I think the past we can talk with certainty what it was about. Like I've said, like FGM has been an issue. The treaty bodies have been talking about it, backward culture. But these new ones, I think the jury is still out again. Let's see what comes out of that. Thank you.
And I'm informed that you are a participative audience, so we'll take very questions you can address to a specific speaker, you can address to the entire panel. We have responses, then we move to the next session. So who wants to take the first bite of the cherry?
You have a question. You are asked to face the camera when you're asking a question. Introduce yourselves as well.
Good afternoon. My name is Jacinta Kanda, and I have a question for the panel. And the panel can choose to delegate the question. And in this specific part of the Constitution, you're talking about enforcement of the Bill of Rights, and you've talked about human dignity and how this Constitution came to protect the mwananchi. And what was said today, that we are not only wananchi but wenye. And my question is on two aspects: how the Constitution has failed to, and in relation to what Prof said, that an ordinary mwananchi does not have the capacity to enforce, and how you need resources or these organizations that are not funded by the parliament. In relation to the rights of the minorities, particularly the Ogiek and the Enderois, how the courts have failed them twice in terms of instituting their suits in Kenyan courts, and how the Kenyan government have failed to this date to implement the decisions of the African Court and the African Commission on their rights to their ancestral land and in protection of their rights generally, and how our courts can have implementation mechanisms the way the African Commission and the African courts have rapporteurs and committees that does implementation of the court decisions, so that court decisions do not end up being an academic exercise, especially for socioeconomic rights like evictions and right to housing. Thank you. My name is Jacinta Kanta, and I'm advocate trainee at the Kenya School of Law.
Thank you. Please keep your comment short.
Yes, I'll be very short. I'm Nabinto Anchiko, and I'm a proud student of Kabarak University. So my comment is mostly on, again, I'm just following up with my morning question: how law has been used has been used to legitimize and normalize suffering of the poor, because it's just a question that is out there. And so I think this conference is a good place to ask this question, to see mainly how law can be how we can rethink law and give it its transformative purposes, why we needed law for at the first place. So I think it's good to look at the relationship between law and right, but in a capitalistic view, in a sense where rights are most tied to buying and selling commodities. For instance, when Jacinta mentioned rights to housing, for me, right to housing means for me to acquire a house, I need to purchase it from the first place. But maybe for someone else, right to housing means the state has to give me a house. That I think that's a question we should think about, because in this sense, rights become mostly mainly promises than guaranteed realities. And another point I wanted to add is, since rights are promises, it means there is institutions that law itself has created to construct and sustain it by enforcing or fulfilling these promises. So maybe my question now will be, how can we ensure that these same institutions are working in the interest of the people? Because I've heard the panelists say, not the panelists, but the moderator ask, what if the country say we do not have money? And I know many people will say, progressive realization of rights where we have to go outside and ask for help. What if that help come with other conditions, which we are seeing now, let's say with Gaza, for them to be granted, not even granted, rights to sovereignty, it comes with some other conditions. And I'm how can we solve these questions? Thank you.
My name is Joyce. I'm from the community. I have two questions. I would like to address the panel. How long does it take for a right to become a constitution? Another question is, at what point do you leave a right to the mercy of our Lord? Noting that you have gone through the progressive realization, as one of the panel members have said, or the enforcers have failed to implement it. Thirdly, I would like to know, what does it take for a normal person like me, who is just a community member, who has not gone through the law school, who even doesn't know the ways of the courthouse, to create a right? Because Madame there has said that a right is a privilege to create a legal thing. So what do I have to go through to create this right? Noting that I'm not a law student, I don't have I don't have the resources to employ someone like a lawyer to fight for me. And maybe I've just written that letter that I was asked to write as I've noted down that I want this right to become a constitution. And then I cannot even go to the courthouse because mtu wa kawaida akionekana kule anaulizwa unafanya nini hapa. So inanigharimu nini ama inanichukua mimi mtu wa kawaida? How will I go upon that?
Thank you very much, Miss Joyce. Sorry for that, sir.
I'm a community member from Rafiki, and we don't have a water borehole within.
Start with your name, sir.
Patrick Barasa, community member. I'm from Rafiki, and we don't have a community borehole. How can we realize that right to access clean and safe water, as enshrined in the Constitution of Kenya?
Thank you, Mr. Baraza. Now, we will start from the left, going to the right, and anyone will take a question or two and see how far we go with them. Prof. Ambani?
Yes, thank you for those very brilliant questions. I'll answer randomly, but I'll be happy to start with Joyce's questions. Just questions, and I think they're quite pertinent. I understood your question in two ways. One, what would you do to get a right in the Constitution? Remember, we've just said that the Constitution doesn't say, or doesn't even claim, it has an exhaustive list of rights. We can always have new rights. Some of us have been thinking that a right, for example, to electricity needs to be thought about. The right to internet, I think, my view. And I don't know. Is it possible to exist in the next 20 years without internet or power? I'm not sure. Somebody needs to think about that as a very serious human rights. How do you ensure that is in the Constitution? There are very many ways of doing that. One is to seek constitutional interpretation through courts. They can interpret. Second, but most serious, is to struggle. And when you ask me about rights, Mr. Nkarichia, I couldn't answer because I know of many theories that explain rights. One of them is the struggle theory that we were taught at the University of Pretoria, that when people feel burdened enough by an issue, problem, challenge, whatever, they will be able to pull together and struggle for that right. When it's heavy enough on their shoulders, they will fight for it. And when they fight for it, it will acquire recognition as a right. Each of the rights you see in the Constitution have had their own struggles. I think the one we've all seen is women struggling for recognition, women's rights. We've seen that. We are now seeing LGBTQ, for example, struggling, and they've been fighting. And their rights are beginning to be recognized in different countries. So if you think something is very close to you and not recognized by the Constitution, I think struggle is a very easy way to go. Not easy, it's a tough one because it's actually written in blood, but that's one way of ensuring you are recognized. But I also took your question to mean, how do I enforce my right? And the enforcement mechanisms of the Constitution are there. I think we've been discussing some of them. One is the courts. We've already said courts are many times expensive. The procedures of approaching them are technical, and many times they're not accessible to the ordinary mwananchi. Which is why it is good to have human rights groups among our people, NGOs, some which can take up cases for you. At Kabarak University, we have started a center, which is called Center for Legal Aid and Clinical Legal Education. It's called CLACO, in short, CLACO. It's able to take up cases on behalf of community and go to court. Since we have many advocates here, including on this panel, who teach in this school, we are able to help volunteer and take up one or two cases and help the needy members of society who then have a case. I'm sure somebody else in Nakuru is also doing something like that, and another and another. That could be one way we help ease the challenge of constitutional litigation or human rights litigation. The other way is that the Constitution has provided for semi-judicial bodies, which is what I was talking about, Article 59, where I was talking about Parliament has written a law to make reality to that by establishing three bodies. One is the Gender Commission. It's called the National Gender and Equality Commission. The other one is the Kenya National Commission on Human Rights. Then the other one is the one we call the Ombudsman. You can use any of these forums. They are quite informal, not as much as strict as the courts. You can approach them. And if you don't know how, I think, again, these bodies in society should be able to help. I think as Kabarak now, normally we try to have clinics within this community, for example. Let's work together, Joyce. I think from here, make sure you get our contacts so that you see how we can approach each other to engage these bodies. And now you can go internationally. And that also takes me to the question of Endorois or GIEC. There are also courts now beyond us. One of them is the East African Court of Justice. The other one is the African Court of Justice, we can go to those levels. And each one of them has been willing to take on matters that affect ordinary people in the African countries. There's a way to approach them. Again, you need to work with organizations that can access them for you. But if you have knowledge enough, I think you can still access them. But if you look at that question that I believe it's Kanda was asking, you will see that there's still a problem of implementation. And that is actually true, not just to this case of these cases pertaining to Kenya, but many other cases. For example, the African Commission, African Court, even East African Court of Justice have been facing the question of, after they have pronounced at that regional level or international level, how does it come home to become law? I think vigilance is still important. I think we have to unite as a people and enforce our rights. If I was to answer only those two questions, vigilance is the thing. Education, civic awareness, forums like this. Nowadays in Kenya, if you invite people to a conference, they ask you whether you'll give them an allowance. And I think that is how they have divided us, the politicians. If we come together constantly, freely and strongly as a people to talk, they will begin to listen. If we come together as the Kenyan people and agitate for these rights and take a record like we are doing of how far are we with Katiba, they'll begin to listen. I believe there must have been pressure on the president for him to declare Katiba Day. He has just done that. The 27th is Katiba Day. And though it's not a holiday, but at least we shall mark it. Once we use those opportunities to push, and where possible, I think street is still a place to go. Demonstrations, picketing, those are still part of the options we have. Using institutions like this university to talk about it, to publish, I think that's one avenue we can use. But I think the bottom line for me is to realize rights, you have to fight. Otherwise, they won't give you. I just wish to conclude by saying that because I'll be asking for permission since I'm the one also organizing here, I'm needed elsewhere. Just to mention that this Bill of Rights was not given on a silver platter. I hope we can remember that as a people. We had to struggle. People like Itobi Manyara, who spoke in the morning, was in prison several times. You guys know that, maximum prison. He was in cells several times, fighting for constitutional reform. It is not that politicians or some well-wishers somewhere woke up one day and decided to give us the constitution. We had to fight, and people lost lives. There are people living with injuries up to now. There are people having a disability arising from this. And the bottom line for that is that we must safeguard that freedom that we got. We must safeguard that Bill of Rights, and the only way is eternal vigilance. I think, Chair, that is what I would recommend going forward. Otherwise, thank you very much for your questions, and I'm sure the others are going to continue the conversation.
Yes, thank you. I'll have less to say. Maybe just in response to Jacinta's question and Nabintu's question. At the center of it all, on how we can get institutions to work for the people, and also generally on the enforcement of human rights, I think the faithful obedience to the rule of law is at the center of it. Because without institutions, without persons respecting the existing provisions of the law, we will not have an effective implementation of the Bill of Rights, and institutions would not work for the people. I think Professor who has just left can tell you that between him and I, we have a court order directing a government institution, a valid document from the court directing a valid government institution to perform a certain act which had infringed the right to education of a minor. And the institution just refused to implement it. So what more can we do? I went to a certain forum where somebody asked, are there extra constitutional means that citizens can use to enforce the Bill of Rights? I almost agreed with them, but then I realized that there's too much danger into it. I realized, for example, if you look at, let me not call them not so good examples of democracies, people would go after CEOs of government parastatals. People would go after their children. People would go after some of those extra constitutional means just to try and enforce the Bill of Rights. Then it brings a moral question. Is it justified to bring extra constitutional means to enforce the Bill of Rights? Some have tried. It works, but at a great expense to the existing rights. So I would gladly appreciate if government institutions and also us as citizens, we are faithful to the rule of law. That way, we would be able to enforce the Bill of Rights fully. I believe Professor responded to the question by Joylin quite clearly. Patrick had raised a concern that they do not have a borehole in Rafiki. I also don't have it in my village. But the correct thing to do is to visit, I think, the Center for Legal Aid and Clinical Legal Education here at Kabarak. You'd realize one thing. There are different functions of different levels of government. For example, the borehole one is a delegated function to the county governments. I think if you consult with our legal aid department, we could be able to raise an alarm to the concerned authorities, which I believe should be your county government, for it to be effected. So we can initiate that, I believe. I think that will be my brief response.
Yeah, I think most of the questions have been answered, but maybe to add on the question of Joyce, if I got you, you ask how long can it take for a right? Like, for example, you need a right to have clean chairs, and you want it to be constitutionally recognized, and you wanted to know how long it can take. Again, I think there's no correct answer to that. It depends, because even if I talked about the right to internet, it's something that happened. Like before we got there was a ruling in 2017. Then there was a case filed in 2020, but it's only in 2025 that the court had recognized that was also a fundamental right, because we have to access information. But still, even though they have mentioned it, it's a problem that is continuing persisting, because even during demonstration, the changes movement and all those things, as you can see, they still shut down internet. Sometimes the Twitter X will not work, and many other social media, because these people and this other. And I remember recently I was in another conference where someone was telling us that they get letters from the government threatening them to even delete some of the things on the internet, or they just block their account, so they don't have any access. So even though it has been mentioned, it's still in progression. So we still need to fight more for that. And maybe some few years from now, it can still work, or we will also get where we want to get. So it just requires persistency. Yeah. And maybe to add just something on what Nabintu said, I believe Cedric responded well, but it does not only, it's not only about how you understand the Constitution or the Bill of Rights. I think it's not only about the Bill of Rights, but the interpretation of the Constitution. That interpretation problem is for the all Constitution, and we are still fighting for that. People are still taking some of these constitutions or right are just defined or interpreted in a way that advantage some people or on the discretion of maybe the court. But also, we can also look at the language problem that my colleague Cedric Katiba mentioned before. Yet, yes, we are still talking about interpretation, but what about people who don't understand English? What about people who don't speak English? I remember I failed my constitutional law unit in first year because I just didn't know what I was doing. It was hard. It was tough to interpret the Constitution. And we also have a bad lecturer. But yeah, it was Prof. and Kadima. But it was really difficult, first because I needed to translate it from French to English, but also after translating it, I also needed to now understand and interpret what I'm getting from that Constitution. So it is a very big problem right now, and I believe that moving forward for the next 15 years, we can still do better and find a solution. Maybe we'll have Swahili Constitution, or maybe we will get to a point that we have it in every language, and yeah, some better interpretation, without also forgetting that they change with societies. Every time we progress and when the society gets developed, these rights are also interpreted in a different way. But yeah, we can continue this discussion even over lunch. Thank you. Over to you, Brian.
Thanks. I think I'm going to respond to the unanswered questions from Nabintu. First, you asked whether law is being used to normalize suffering of the poor and such instances, especially on the realization of socioeconomic rights. I am of the view that yes, law is being used in that sense. Not its intention, but the way it's being implemented. I'll give an example of the aspect of progressive realization and the aspect of the government proving that indeed it does not have the budget to fund those socioeconomic progress. We are well aware that we suffer a case of endemic corruption in Kenya. The 23-24 ESC reports estimated that we had 16 billion untraceable illegal assets, and out of those 16 billion, only 2.9 billion were recovered. Now you can imagine the deficit that is between that 16.2 billion and the 2.9 billion. That deficit could be used to implement socioeconomic programs. So I think, yeah, to an aspect, I'd say that, yeah, the law in itself does not help our cause at times, but it's all a matter of implementation. You also asked on the question of we might go for loans, or we might have sovereign debts, and they impose some certain condition on it. But I'll make reference to Alex Tamei's paper on sovereign debt acquisition, whereby Tamei stated that debt servicing must not undermine core human rights. In as much as Kenya, yeah, we need to borrow loans to fill the budget, but those loans should also have its own purpose. We should use those loans to advance our socioeconomic programs. Yeah, I think that is to Banabintu. And the last, I'll maybe add on to Kadima on the response to Baraza on the borehole. And in as much as, yes, the community does not have a borehole, I think as trends have it, the court will carry out a proportionality analysis. You don't have a borehole in the community, but is there any way that you can get water in the community? Is water so scarce that the government is necessitated to build that borehole? However, that does not mean that the government should not build a borehole. It's just a matter of proportionality analysis and the needs that are most wanted by that community. Yeah, thank you.
Thank you, Mr. Kipchumba. Mr. Baraza, everyone here is giving you stories. I will tell you it's possible to have a borehole. If in 2027 you vote for the right governor, that solves 90% of the problem. The main challenge you have in the Kenyan legal framework is you anticipate a government by delivery. But you expect that the CDF, when it's with the MP, then it will give you progress. You forget all this money is taxes that you have already paid. The government does not have a business where it makes profit to invest in the community. Every shilling spent by Ruto, Kindiki, Murkomen, all of them is money you have paid as taxes. So if you have a responsible leadership, that will be a very easy thing to resolve. My firmest opinion is that every human right you desire to have, the first step to realizing it is having a responsible government. Because when you have a responsible government, it either delivers the means for you to access all your rights, or it facilitates your enjoyment of your freedom. But when you have a government by a thousand bob so that you vote in the next election, they will always tell you, I gave you the thousand, you voted me. Our transaction is over. So if you try and have a responsible leadership, I think almost all our socioeconomic problems will disappear. Now, I don't think there's someone's question that remains unanswered. No. And to finalize on the first question asked by Jacinta, the Kenyan courts have not failed as in our quest to realize minority rights. You must appreciate Kenyan government and Kenyan legal system is unaenda kuomba judge order fulani. Ukiandika ombi lako vibaya, koti iwezi kusaidia. Enterprise community, all the minority communities we have. Shida huo ukienda koti, unaenda koti kuomba usaidizi wa namna gani. Ombi lako likiwa gumu kidogo kokoti kuelewa unachohitaji, hautasaidika. When the prayer you have before the court is couched in such terms that the court cannot assist you, you will not get assistance. And I'm talking this as a legal practitioner. What we do Monday to Friday. It's the same reason you think the law protects the rich, but because the rich are able to access lawyers who can be able to file their petitions very well, they appear as if the law protects them. But even someone has misjudged there. Hata kama wewe si wakili, ukienda koti na maombi yako, ina maana that it's specific, identifiable, and actionable. You will be able to be assisted. You will forgive me for mixing Kiswahili and English. I'm realizing Kiswahili is not my best language. But is there other three questions? Then I think we wind it up. I see someone looking at me. In a month, suggest time is up, but we'll take the last questions and wind it up. Thank you.
Good afternoon. My name is Joshua Kibati. I'm from Eastern University Law School. Another question. Since we came here, almost everybody is blaming the government. And as for me, my issue is not just about the government, but also the society. In Kenya, we have normalized injustice. We view justice from one angle. If you lynch somebody, it is okay with the citizens. But if the government shoots somebody in the head, that's illegal. So how are we going to balance? Because most of the injustice in these countries are done by Kenyans against other Kenyans. Then the government acts as a third party. How are the people going to be educated and accept the law the way it is? Thank you.
Hamjambo. Kwa majina yangu ni Joseph Chesa, na nina swali ambalo huwa inanisumbua sana. Nauliza, hii katiba ni mbaya ama wenye kutekeleza ni mabaya? Kwa sababu naona inaweza ongelewa haki ya upande mmoja na upande mwingine haiongeleshwi. Nimeona mtu akipika mawe polisi, kapika mwanamke ambao ni polisi, women, anaanguka, na yule mtu alitupa mawe anasemekana haki yake amekosewa, na yule amepikwa mawe hajaongelewa. Sasa mimi nikashindwa. Unajua unaweza pika polisi mawe akiwa na punduki, kichwa asunguka, anafikiria anapika risasi juu, na kumbe anapika hivi inakuza mtu. So kwa hivyo ningetaka mtuambie nani analinda haki ya yule mtu ambao analinda wengine. Hii haki ina upendeleo upande moja na anashughulikia upande mwingine. Asante.
Thank you very much. My name is Peter Rono. I must say that this conversation is timely when we are speaking about the Constitution. I must appreciate the 15 years of implementation of the Constitution, what we have seen, what have changed, and where we are at the moment. I have a couple of things. One is concerning the interpretation. Why is it that we have to do interpretation of the Constitution? That's something I've been asking myself. Should it be straightforward? Yeah, so that everyone can be able to read and understand. Then if those of us who have faith, we go to church, already we have Bible interpretations. Is it timely for us as a country? We also have an interpretation version of our Constitution. For me, that will try to eliminate quite a number of things. Concerning the implementation of the rulings by the courts, I think, and this is something that I've been looking at it, there are no consequences attached to it. Yeah. For instance, if the government is told to do something, it doesn't do it. No one cares. Nothing is done. So does it mean that there are no consequences attached to it? Yeah. Then lastly is that this one is a comment, is an opinion. I'm not a law student. But every time we leave critical matters in the hands of political class, yeah, we are bound to have a rough time. So for me, that's my take. And maybe lastly is, do courts also play a role in the delay for justice? Because as is from community, courts do take time to give pronunciation, maybe 4 years, for those that have seen. But again, does that mean that we are constantly delaying the justice for that person whose right has been violated? Thank you very much.
I'm informed we are meant to pick our lunch coupons. The food is hot and spicy. So maybe if the discussant or whoever wants to answer all those questions quickly, and then when you're exiting, you pick a coupon. And I won't say anything else as a moderator. We'll just go.
Thank you. I will give each 30 seconds. Try and see which question you can answer straight. Then we try and wind it up. Thanks.
Okay. Few attempts to those very hard but very important questions. But question by Joshua: have we normalized injustice, and why shouldn't the people now just take the law as it is? Indeed, the rule of law is again a very important factor about it. Each person should respect the law as is. This links to the question of why do we need different interpretations by Peter? Because maybe different interpretations create absurdity. Of course, again, the paradox is, without interpretation, absurdity could be there. So interpretation, again, is important. But again, under just interpreting the Constitution as is or interpreting rights as is, there are different versions on how to interpret it. There's a person who will just read it textually. Our abilities, again, dictate. There's another person who will read it differently. That's why we have another mode of interpretation called a harmonious interpretation, whereby now we take all these other views to try and reach at a conclusion that is favorable to all of us, or each provision agreeing with each other. So interpretation is actually very, very important. Lastly, Joseph aliuliza swali kama katiba ni nzuri ama wenye kutimiza katiba ndio wabaya. Hii katiba duniani mzima kote imeweza kusifiwa kuwa ndio nzuri zaidi. Shida tu ni sisi ambao tunatekeleza hiyo katiba. Na sisi ni yule mtu ambaye ulipigia kura, wewe mwenyewe, na hata ule ambao kumpigia kura. Sisi ndio wabaya. Kuna mwalimu mwenzangu wanapenda kusema kwamba Wakenya tuko na tabia mbaya. Na hiyo tabia mbaya ndio inafanya tusiweze kutimiza hii katiba. So tukisi Wakenya wenzetu wawe tuna tabia nzuri. Katiba ikisema usitupe uchafu, wewe usitupe. Katiba ikisema pigia mtu kura bila kuchukua pesa, wewe usichukue hiyo pesa, wewe piga tu kura. So tukiwa na tabia nzuri kama Wakenya sote, kama ni polisi, kama ni mwanasiasa, kama ni wewe mwenyewe nyumbani na baba na mama na watoto, ukiwa na tabia nzuri, katiba itaweza kutimizwa vizuri. Nafikiri hayo ndio majibu yangu. Asante.
So for the person who asked about what about Kenyans who killed each other, and why do we only talk about the state? Can you remind me? Yes, Joshua. So I think we blame more the state because the state is supposed to protect our rights. That is why we first blame them when something happens, you know. When we go to demonstrate, we are demonstrating because they didn't do what we were expecting to them. Then when it happened there during the demonstration that for example, someone stabbed another person or I don't know what, we will still blame them because they were supposed to make that protest peaceful. It's part of their work first. But also, I think nothing prevents you to go and sue your other fellow colleagues who has done something to you. You can still sue that person. And if the problem of costs and I don't know what came up again, they still have other alternative justice system in Article 149, I think too. There is ADR and yeah, but most of the people, again, will prefer to do this in a traditional way of resolving. I remember someone was telling us the other day about, I think, a community where if you kill someone, if you kill their brother, they will tell you to bring I don't know how many cows, and it ends there. So it's not like the state is preventing you, or we are not blaming, but I think people are more diligent when it's about ourselves than the state who is supposed to protect us. And I think that also applies to the question about why do we only, someone talked about policemen, and why is it only a big problem when it's the state who has done something, but we are not blamed when we do, like when we return. Like I can say that ours is mostly considered as self-defense compared to the people who came voluntarily or with the intention to do this thing, this other violation. Yeah, maybe Brian will complete that. Thank you.
Just to complete on what Kenaya has said, Chesang aliuliza mbona kati mwananchi atarushia mawe polisi, lakini huyo mwenye ametupa mawe ndo atakuwa hana makosa na polisi ndiye ako na makosa. Ukienda kotini, kuna kila mtu anaweza peleka mtu yoyote kotini. Hiyo ndio sana naita horizontal application. Lakini sasa ikibainishwa kuwa aliyetupa mawe ndio mwenye makosa na alianzisha, yeye ndo atakuwa na hatia. Lakini ikionyesha kuwa alikuwa anaifanya vile Kenaya amesema in self defense, hapo hivyo ndipo atapatikana mwenye makosa. Tunaita evidentiary burden. Can you prove that you are not the one who has the fault? Are you not the one who instigated that thing? I think that answers the question. Chesang, natumai nimekujibu swali. Yes. Asante.
So thank you for everybody. Someone said implementation of court orders, there is no consequences. There's a lot of consequences in Kenya. There's something we call contempt of court. If you have a court order and someone is unable to comply with it, you can institute contempt of court. But at the end of the day, it's how as Kenyans we strive to engage. We remember Finance Act was passed by Parliament, but people went into the streets and it was kicked out in 2024, which means some of these decisions that Katiba was referring to extra constitutional means. Sometimes maybe shaming someone in social media will get you a better outcome than trying to enforce a court order. But maybe even sometimes going through the constitutional process of contempt of court will get you the outcome you desire. But it's a healthy conversation that we can have after today. Thank you everybody for making the time. You can walk out, grab some lunch. You're being requested to be back by 2:30 so that we can be able to have the evening session. Thank you.